All right, so we've got a big update in the Mark and Patricia McCloskey case. Mark and Patricia McCloskey are two lawyers who became internet and then world famous for brandishing firearms during a mostly peaceful protest outside of their St. Louis, Missouri mansion. They were out on their own lawn pointing guns in the direction of protesters, telling them to move along, get out the way, get off our property, get away from us. You don't want anything to do with what we've got here. Mark was wielding an AR-15 style rifle, and Patricia had a small handgun, which was allegedly non-functioning at the time, and they knew that it was non-functioning. So, with that said, they were charged with felony level assault crimes involving firearms, and those charges were very serious. Now, they had a tentative promise from the governor of Missouri to give them pardons, but they did not actually have secure pardons, and we'll talk about that in a little bit. But a lot of people are confused as to why they have now pled guilty to lower misdemeanor assault charges to close out this case. They have questions why they would do this. One, if they're not guilty. Two, if they have a promise of a pardon. What is the purpose of this? And I think I can answer that from a defense attorney and legal strategy perspective on why a defense attorney would advise a client to do this and why these particular clients would follow that advice. All right. So with that, let's talk about it. I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer. I'm also a legal and political commentator on YouTube and on Odyssey. Wherever you're watching, go ahead, hit like, hit subscribe, turn on those notifications so you don't miss any videos. All right, first things first, I got to give a shout out to my man, Viva Fry. He is a Canadian lawyer and a fantastic YouTuber, and he has done a video on this, and in which he implies that this might be a giant mistake. And Viva's video is very, very good, and everything he says is correct in that video. Now, I don't think this is actually a giant mistake, but I can see the principled reasons why Viva would say this. He is not wrong on those principled reasons. We're going to be talking about practicality. As often happens in criminal law, you have to get down to practical applications of law and fact. So here we go. If you follow up here where my finger is, there should be a little button, and that's going to have a link to Viva's video on this. You can also probably find it down in the description, and you should check it out because it's a really well done video, and it's going to give you some of the other backstory stuff about the prosecution, how corrupt the prosecutor was, and all of that stuff. He's also done great coverage of this case in general. So that being said, shout out to my man Viva. Keep doing you, buddy. Great videos as always, and let's get into this and fill in some of the gaps. So here it is. St. Louis gun-waving couple pleads guilty to misdemeanors. All right. So here they are, the McCloskeys. They're out in front of the courthouse. St. Louis couple who gained notoriety for pointing guns at social justice demonstrators who just ripped down a gate onto private property and were encroaching upon their personal private property, despite the fact that the road that they were on was also private property. It's not like this is a public street. It's not. These people were not welcome in this community. Okay. They pleaded guilty Thursday to misdemeanor charges, but the man left the courthouse defiantly pledging to do it again if faced with the same circumstances. And of course, his actions were effective, and his penalty ultimately for someone in his position is de minimis. This is a very minor penalty for what he has done. And so ultimately, yeah, he should make the same decisions, of course. Patricia McCloskey pleaded guilty to misdemeanor harassment and was fined $2,000. Her husband, Mark McCloskey, pleaded guilty to misdemeanor fourth-degree assault and was fined $750. They also agreed to give up the weapons they used during the confrontation. When several hundred demonstrators marched past their home in June 2020 in a private gated community on a private road, the couple waved weapons at them. They claimed the protesters were trespassing and that they feared for their safety. These were statements that they made contemporaneous to the incident, and those are critical statements in defense of home with a firearm that they were going to, if they fought this, if they went ahead and fought this, they would be using those statements as evidence of their reasonable subjective fear for imminent bodily harm and imminent harm to their property as a justification. Now, they didn't have to fight this because of their plea, but this was the setup for it. The McCloskeys, both of them lawyers in their 60s, wore blue blazers and spoke calmly in answering questions from Judge David Mason during Thursday's hearing. Mason asked Mark McCloskey if he acknowledged his actions put people at risk of personal injury. He replied, "I sure did, Your Honor." And he's taking this very cavalier, sort of brazen attitude. He did put them in danger, he's saying, and he'd put them in danger again to defend himself and to defend his home. "I'd do it again," he said from the courthouse steps in downtown St. Louis. "Anytime the mob approaches me, I'll do what I can to put them in imminent threat of physical injury because that's what kept them from destroying my house and my family." So, that being said, that is sort of the rationale behind his actions, okay? Is that he's putting them in imminent threat of bodily injury. And of course, that is the point of using force against someone who is putting you in danger, is to put them in enough fear of danger, or to actually put them in enough danger that they disengage or get killed. Whatever it may be, whatever the outcome may actually be in that case, that's the purpose of utilizing a contravailing force. So this all makes sense. This is all well and good. But why are they pleading guilty? Because technically, we have what should be a justifiable use of said force. We have them being in reasonable fear. Anybody in that situation should be in reasonable fear for imminent damage to them and their property. You've got an angry mob that just tore into a gated community that is not supposed to be there. They have been known to cause significant property damage, even destruction of property entirely. You have no idea if you are going to be safe, where their anger may turn, all of that stuff. So they engage in this very reasonable use of force to defend themselves, in my opinion. In my opinion. However, this is the however, and here's the practical aspects of it. These are felony charges that they had at first. Now, they pled guilty to misdemeanor charges. If those misdemeanor charges will not implicate their law licenses and will not implicate their ability to own guns. The federal felony, or the felony charges, the Missouri felony charges, would implicate their ability to own guns and may actually implicate their law licenses as well. Now, sure, they have a defense for reasonable use of this force, but the way that affirmative defenses work is that you're basically admitting to the underlying acts which would otherwise constitute a crime. So if your defense fails, if your rationale, your justification is not accepted by the jury, then you're guilty because you've admitted to the underlying facts. And the underlying facts in this case were that they brandish weapons as direct threats towards these people. Now, they say, I did that, but I did it justifiably. If a jury says, wasn't justified, then they're guilty. Now they've admitted to the facts, they are guilty. At that point, they lose their firearms. They may lose their law licenses. Now, for everybody who says, well, the governor was going to pardon them, the governor said he would pardon them, and I'm going to take him at his word and say, yeah, the governor's probably going to pardon them. However, we've got to take a look real quick at a certain law, and this is 18 USC 922 subsection G1. This is the law which says when you can own and possess firearms. Okay, it shall be unlawful for any person, one, who has been convicted in any court of a crime punishable by imprisonment for a term exceeding 1 year. So unlawful for them to own firearms or possess firearms the moment they are found guilty of this. Now, when you get a pardon in Missouri, Missouri does not have a preemptive pardon power. The governor cannot say, you are pardoned for this crime in advance. They have to wait for a conviction and then issue a pardon. This is different from the federal pardon power. A president can actually pardon people for crimes that they haven't even been charged with. They can issue a pardon to that person, and then that person is not adjudicated guilty of that crime. They have not been found guilty beyond any reasonable doubt by a jury of their peers. They are not guilty. If a pardon occurs after a felony conviction at the federal level, they have been found guilty, and there are implications from that, depending on the types of crime. Okay, now a pardon is supposed to alleviate you from all of these difficulties, and arguably it could. Arguably, you could be alleviated of the underlying criminal act through a pardon from the Missouri governor. So they would have been convicted in any court of a crime punishable by imprisonment for a term exceeding 1 year. They lose their right to the firearms. Missouri governor comes in and says, "You are pardoned. Voila, your rights are restored." Not actually true. Not actually true. The act of getting your rights restored at the federal level is a costly, very costly process, and it may not happen. They don't actually have to do it. You have to ask federal agencies to go ahead and instigate this process. And if they don't do it, you have to sue them and get the court to force them to do it. And that's also a very expensive process. So what we have here, this is the ultimate conclusion. This is where the defense lawyer legal advice comes in on this, and the practical application of law to the facts at hand is we have, all right, you have felony charges right now that involve firearms. If you are found guilty, if you are convicted of this, you will lose your guns. You may lose your law licenses. And not only will you lose your guns, you will lose your guns forever. You may lose your law licenses. You may end up in prison for an extended amount of time, or for any amount of time. And this felony will be with you for quite a while. So that's if you're guilty. Now, you may be able to beat the charges. You have a good case for justification. There's been all sorts of prosecutorial corruption, but those prosecutors are actually gone. New prosecutors are brought in. They're going to prosecute the case. Presumably, they could get rid of any of the corrupt sort of activities that had happened, take the case at a reasonable pace, and go ahead and prosecute it normally. Now, again, if they're found guilty of the felonies, lose guns, potentially lose law licenses, this is not a good thing for them. Not a good thing. Also, you lose your right to vote and all that stuff. Or, conversely, they can plea to a misdemeanor charge. Mark can pay $750 and give up a $1,500 AR, and then he can buy another AR, because this couple has millions of dollars. They have a very nice house. They're able to go ahead and afford that. That is a pretty insignificant expenditure for the preservation of their rights and their professions. Patricia pays another $2,000 and forfeits a non-functioning handgun. Who cares? And now she can buy whatever gun she wants to buy, to replace it. Another handgun, another rifle, whatever she wants to do. So this couple ends up losing out a total of about $5,000. And in the process, they avoid jail time. They avoid felony convictions. They preserve their gun rights. They preserve their voting rights. They preserve their law licenses. And they do so without having to fight for them, without having to rely on a pardon, and without having to, after that pardon, go ahead and continue the fight. This is the practical application of law. Mark McCloskey is now running for the Senate, and he would probably much rather focus on running for that Senate seat than sitting and fighting this legal case for the next 6 to 12 months, whatever that may be. He has other things to worry about. And again, having a senator with a felony conviction over their head, that clouds the sort of that clouds the campaign prospects as well. So what these guys did was they made a practical choice, probably on advice of their defense counsel, to go ahead and take this road. And I think it's the right road. People, we always want other people to make very principled stands on our rights or whatever. The overall outcome, the overall impact on Second Amendment rights, either way, from the McCloskeys in any scenario in this case is minimal. The right was implicated immediately upon the charges being filed, and the right was damaged in that way. If they were to try to fight and successfully argue a justifiable use of the firearms in the way that they use them, it wouldn't actually benefit our Second Amendment rights in any way other than having a story around it. What they did here was preserve their own rights rather than take up the cause for, at best, a nominal victory in the fight for Second Amendment rights. So I think this is a practical and very reasonable choice that they have made. But that's me. That's what I think. I've given you the reasons for it, and it's the type of thing I would advise any client to do. If you can plead a felony down to a misdemeanor with no jail time that doesn't implicate your rights, and you can afford the very nominal fines that they were charged, then you should do it. You should do that 10 times out of 10. It's a fantastic win for this couple who otherwise face some pretty harsh penalties, even with the prospect of a pardon on the horizon. So I hope that helps you understand my perspective on it. I would love to know yours. Drop a comment down below and let me know. All right, guys, thanks for watching. I hope you enjoyed it. Until next time, peace. Peace.